Hello, my name is Elena Pop. I'm the Executive Director of the Eviction Defense Network. We represent tenants in evictions, and we want to help you save your home.
My name is Mark Tarbox, and I'm the Director of TEP Education at the Eviction Defense Network. I'm also a graduate of the EDN Tenant Empowerment Program, or TEP. The Eviction Defense Network is a proud member of the LA County Right to Counsel Coalition and its Stay Housed LA program.
We know your stress. The threat to your home is one of the 5 most stressful life events you will ever have to go through. But stress will stop you from listening and following instructions, and that is the fastest route to a lockout by the sheriff. Overcome your stress through knowledge and power. Help us to help you by following instructions.
If you have a disability, including a learning disability, and need a reasonable accommodation, please let us know.
We cannot have justice without language justice. Please be patient with the interpretation.
You are here in our video series, How to Respond to a Summons from the Court.
You should have already watched these 2 videos that are marked with an arrow on the left. Those explain exactly how you can get legal help. There are currently 4 videos in what we call our One series. Watch all 4. If when you start the program there are 5, then watch all 5. If there are 6, then watch all 6. If you have not watched these 4 videos or 5 or 6, stop and go back and watch them now. You will be lost if you don't watch the videos in the One series first.
Our website is your best friend. It understands your situation. It's available to you 24 hours a day. It has all the information you need to set yourself up for success. If you click on this Start Here button, you will start a step-by-step tutorial of our entire program. Go through it and come to class to ask questions. We have a video and a class for every step of the eviction process.
This is the summons. It looks scary. And it comes with a packet with 20 to 60 pages. We're here to help you understand it. If your deadline to file your answer is today, then stop the video, grab your headsets and cell phone, and immediately go to the self-help center at the courthouse. If you're going to the downtown court on Hill Street, otherwise known as the Mosque Court, then you are going to the Shriver Project. But ask for the self-help center, ask for the Shriver Project, and you will get directed. On your way there, and while you wait to be seen, continue watching this video. If you have a day or two to file your answer, then you have more choices. You can either go to the Self-Help Center, or you can go to the Shriver Project, or you can use the online Tenant Power Toolkit. After you file your answer, come back and watch this video again. To learn how our program works, make sure you watch the 4 videos in what we call the One series, 1A, 1B, 1C, and 1D.
This is a courtesy notice from the court. This notice lets you know your landlord has filed an eviction lawsuit. Before the pandemic, 49% of the tenants that got these forms
Did this.
or this.
Which leads to this, a notice to vacate from the sheriff.
When the sheriff arrives, they lock you out with less than only a 15-minute warning. The percentage of tenants who ignored the courtesy notice from the court went from 49% to 68% during the pandemic because many people thought there was a moratorium. There was never a moratorium. There were defenses to evictions. There is no fire moratorium either, just defenses if you qualify. You must answer the summons and complaint to access those defenses. Unscrupulous landlords will pretend to give the eviction papers to you. Protect yourself by following the instructions in this video.
If you're listening to this video, you have connected with the resources to get the best possible result in your eviction case. Watch the videos and come to class. If you listen, learn, and follow through with our instructions, you will get the best possible result given the strength of your case. So watch the videos, come to class. Watch the videos, come to class. Watch the videos, come to class. Watch the videos until you can teach the class, and then watch them again. And come to class for updates. The information changes constantly. Go to the EDN, Eviction Defense Network, edn.la/webinars link for a current class schedule. We have classes covering every step of the eviction process and classes where you can practice and role play with us, gain confidence, and hone your skills.
I know from my own experience as a tenant in crisis that at this point you just want to know how to respond to the summons and what is going to happen next. And you want someone to just take care of it for you.
There is no one to take care of it for you. And before we can start to help you respond to the summons, you have to have some basic information. Remember, this is about your housing. It's about protecting your rental record. It's about protecting your credit score, and it's about your future. You must be willing to invest the time to learn, to hone your skills, and to develop the confidence to win.
It's time to wax on and wax off.
Let's make a sacred pact. We promise to teach you how to be a winner. You promise to learn. But there is no middle road here. Commit or you'll be squished like a grape.
These are types of notices that start the eviction lawsuit. They come from the landlord. They look unofficial, and you can learn all about them in our video 2A and in our Monday class, 2 p.m., the Zoom class on how to respond to a notice from your landlord.
Evictions start with a notice from the landlord.
If you don't do what the notice says and the number of days stated in the notice, the only thing the landlord can legally do is file an eviction lawsuit. The landlord will then hire someone to deliver the summons and complaint to you.
If you ignore the summons and complaint, you will lose automatically and the sheriff will lock you out.
If you answer the summons and complaint, you will be able to raise defenses in court and possibly win.
Or you could lose.
Or you could settle your case to either stay or move out.
But don't forget to breathe. Now you're like, I have a summons and complaint for eviction. What's my next step? What do I do? Step 1 is to breathe. Step 2 is to watch the rest of this video. And step 3 is to follow our instructions.
We are here in the process. When a landlord files an eviction action, the court sends a separate letter to each person that is being sued. They also send the same letter to all unnamed occupants. These letters warn you that you have been sued.
A process server is a person that has a license to deliver court papers. Landlords and process servers sometimes lie about giving you the summons and complaint packet. So the court sends you at least 2 copies of this letter to warn you that the eviction has been filed. Now, this letter tries to do too much and fails. Most tenants ignore it, but we're going to go through it together.
The notice tells you that an eviction lawsuit has been filed and you have been named as a defendant.
It tells you about state protections and misleads you into thinking that you don't need to file an answer. Don't read this paragraph. It is very confusing. You have to just ignore this very stupid and unnecessary first paragraph that implies that you have more protections than you have, especially now that most of the pandemic protections have been lifted. You must file an answer even if you have these state protections.
These are agencies that can help. We will teach you how to apply to them for services. Start working on this today. Remember, you have 10 days, not including Saturdays, Sundays, and court holidays, from the date you are handed the 20 to 70 page summons and complaint packet to file your answer. The answer must be filed using a specific form from the court. Your clock hasn't started ticking yet, but the landlord or process server could lie about giving you the packet, so let's pretend that the clock has already started ticking.
On your calendar, and you should all have a calendar, mark the date that you got this notice of eviction filing.
On your calendar, the date 6 business days from the day you got the notice of unlawful detainer filing should be marked here.
If you live in the city of Los Angeles, call the Mayor's Fund for Los Angeles for help with your answer. The number is 213 584 1808. Pause the video right now. We will wait for you to continue. By getting an appointment with the Mayor's Fund, you will get extra case management and an appointment with us. Seriously, stop the video right now, call the Mayor's Fund, make that appointment, and then come back.
Welcome back. Another good resource is Stay Housed LA. Stay Housed LA is a project of the LA County Right to Counsel Coalition. Approximately 70 lawyers are providing full scope representation for free in 70 out of the more than 400 zip codes in LA County.
While our program is great and we stand by it, having a free lawyer that is experienced is probably better for most of you. So go to stayhousedla.priorityzipcodes.org right now to see if you are in a priority zip code. You can also just go to stayhousedla.org, find this page, and then click on zip codes.
If your zip code is not on the list, do not bother filling out an application at Stay Housed LA. Come back to this video instead. Seriously, right now, stop the video and go to stayhousedla.org.
If you are in a priority zip code, apply. After you apply, come right back to this video. Assistance is not guaranteed by one of the Stay Housed LA agencies, and you have work to do.
Welcome back. We are here to help those of you that are not accepted by Stay Housed LA. Our program teaches you how to prepare your case for trial, and if a lawyer is available when your trial starts, we will represent you. You must put the work into your case preparation.
And remember, and you will hear us say this over and over, this is boot camp, not summer camp.
Let's put the rest of the dates on your calendar. If you still don't have a copy of the 20 to 70 page summons and complaint packet and or an appointment with Stay Housed LA and or the Mayor's Fund, go to the courthouse on day 6 to pick up a copy of the file from the clerk's office. Be there promptly at 7:30 a.m. Be one of the first in line. After you have your case file in hand, see if you can be seen by either the court's Self-Help Center or the Shriver Project, which is located at room 115 in the Moss Courthouse.
Save 7 days to do this and 8 to try to get help from the Self-Help Center. In other words, don't wait till the very, very last day.
Reserve days 8 and 9 to do the answer on the Tenant Power Toolkit online, just in case the Self-Help Center can't help you.
If the process server, if the person comes to hand you the summons and complaint packet during this time, before you get your answer done, Log the new date. Use a different color. Here it says served in person in green.
Log the new day 10, but don't alter your schedule. Get this done by the original deadlines you set. The faster, the safer. Too much trouble to do all of this? Don't want to bother?
Hire a private attorney. Come to any webinar to get a current list of the private attorneys that help people with evictions.
Or get ready to meet your local sheriff.
Let's go back to the notice of unlawful detainer filing. Community Legal Aid, SoCal, Bethesda Legal Services, Legal Aid Foundation of Los Angeles, and Neighborhood Legal Services are all part of the Stay Housed LA Coalition. If you are in a priority zip code, you have already applied for their services through Stay Housed LA. If you're in a priority zip code and you were assigned an agency, follow up with that agency if they don't reach out to you.
We don't recommend this number for the LA County Bar. Most of the lawyers on their referral list represent both landlords and tenants. If you get a lawyer from this source, make sure they only represent tenants.
We do recommend this number for the LA County Bar and this email for the LA County Bar. This particular service of the bar provides free services to veterans facing eviction.
Back to the notice of unlawful detainer filing. This paragraph tells you about reasonable accommodations for persons with disabilities.
If you have a disability and need a reasonable accommodation, go to lacourt.org and request disability accommodations by clicking here where the blue arrow is pointing. Examples of reasonable accommodations include a sign language interpreter, equipment to amplify sound, and if you can't travel far, asking that the case stay in the court where it was filed, rather than being sent to trial to a court far, far away. You can also request to testify remotely if you are homebound.
We are a very diverse community.
224 languages are spoken in the county of Los Angeles.
Spanish is the most common language spoken in LA County, and folks that are monolingual in Spanish are second only to English speakers. Spanish interpretation is available in all courtrooms without making a special request. Interpretation in other languages is available, but
You must make your request here on the front page of the lacourt.org website. See where the blue arrow is pointing. Click there to request an interpreter if you need an interpreter other than in Spanish.
this paragraph with the blue arrow pointing explains that the record is sealed. This statement is not accurate. It states the status of the law before 2017. Under the current law, records are sealed until the case is finished. They can unseal if you lose the case in the first 60 days. If a record is sealed, it can't be reported or shown to anyone except the parties and their lawyers. We insist that your case be sealed unconditionally when we settle a case. The record won't unseal if the case is dismissed, which means the case has been canceled. If even one defendant is dismissed, the record will stay sealed permanently for all defendants. The record won't unseal if you win. The record could unseal if you lose. Once a record unseals, it does little good to seal it again because once the credit reporting agencies have the information, they will report it, even if the record is resealed.
The courtesy notice sometimes comes before that 60, 70-page packet with the summons and the complaint. Sometimes it comes after the summons and complaint packet. Sometimes it comes and the summons and complaint packet never comes. And sometimes neither come. And you find yourself being locked out by the sheriff without ever having known that an eviction was filed.
This is why you need informed delivery from the U.S. Post Office. Sometimes mail is lost. Sometimes unscrupulous landlords steal your mail to deny your right to have your case decided by the court. If you get informed delivery, the post office will send you an email with a scan of all envelopes being sent to you. If you get an email from the informed delivery showing mail you should be expecting from the court and the envelope does not arrive, go to the court, show them the scan, and get a copy of what's inside. While you're at the courthouse, fill out an FW001 form, which we will show you in a little bit, and ask for your full case file and a printout of the Registry of Actions. The Registry of Actions or Case Register is a summary of all the papers that have been filed with the court and all the court hearings that have already happened.
And now it's time to paint the fence. Take a break before we move on to the summons.
If you took a break, welcome back. If you didn't take a break, don't complain that the video is too long. Remember,
This is boot camp, not summer camp.
the titles of all court papers are at the bottom center of each page.
And the number of pages the document is here on the right. When we ask you to send a document, make sure you check the title at the bottom center and make sure you send us all of the pages. Let's look at the summons together.
Summons means you must come to court. The sheriff will kick you out of your home if you ignore us. The summons is the paper that gives the court power over you. You must follow their orders.
Unlawful detainer. That's what it says right here. An unlawful detainer is basically your landlord saying you are holding on to the property, detaining the property unlawfully.
Eviction means the landlord wants to kick you out.
Defendant. That's you, the tenant. It could also be another household member.
Plaintiff is the person that's suing, usually the landlord, sometimes a master tenant, sometimes a management company. A plaintiff must have standing to sue you. They must be the owner, a management company with permission to evict from the owner, or a master tenant that's subleased to you. If the plaintiff is not a human, they must also be in good legal standing with the Secretary of State. Lack of standing is an important defense that can be raised at any time. If there was a change in ownership or management, the new owner or manager must tell you that there was a change. They must tell you in writing, and the letter must have very specific language. If there has been a change in ownership or management, please bring the letter with you.
The first paragraph here lets you know you've been sued. It lets you know you have 10 working days to file an answer.
The second paragraph lets you know that neither a letter or phone call to the court is not good enough. Neither is calling the landlord nor the landlord's attorney to negotiate. This summons and complaint packet includes flyers about alternative dispute resolution, which we will go over in a minute. Following the instructions in those mediation flyers is also not good enough to stop the sheriff. Only an answer in a specific format will keep you from losing automatically. First, you answer. Then, at intake and step 10 and step 15, we discuss our goals using the 16 factors to consider. If you don't know what we mean by step 10 and step 15, you haven't watched video 1C. Watch it now and then come back to this video. Don't know the 16 factors analysis? Watch video 2C and then come back to our Zoom negotiations class on Fridays at noon. Next, you start the negotiation.
The third paragraph encourages you to get an attorney. Ignore this state resource. Go directly to stayhousedla.org if you are in LA County. If you are in a priority zip code, apply there. Apply only once. You will immediately be sent an email with an assigned agency. Follow up with that agency if they don't reach out to you. Participate actively in the EDN Tenant Empowerment Program while you wait for them to make a decision to represent you. If that agency says they are not available, then stick with our program.
The fourth paragraph says that if you get more than $10,000 in your settlement, you need to pay the court fees back.
And then the whole other side of this is the Spanish translation.
Before electronic filing, the clerk would put a stamp in this box where you see the blue arrow. Today, all lawyers are required to file electronically. You will only see the stamp if your landlord is representing themselves and filed in person. In some courts, you will see the information printed in this box.
The case number goes in this box, but since electronic filing, this box is often empty.
In other courts, the case number is up here in tiny print. Memorize your case number. We ask for it often, and we don't want to waste time waiting for you to find it.
The name and address of the court goes here where the blue arrow is pointing.
The name and address of the landlord's attorney goes here where the arrow is pointing. Or if the landlord is representing themselves, then the landlord's information will be here. Ladies and gentlemen, I present to you the not so scary after all summons.
Congratulations on getting through this first part. It's now time to take another short break, come back so that we can sand the floor.
But seriously, I have a deadline. When are you going to tell me what to do? Just tell me what to do. If your deadline is today or tomorrow, we have told you to file an answer on time and where to go for help. Stop the video and do that now. Come back to this video later. We are moving on to sanding the floor, and we are going to explain to you the complaint.
This is the complaint for unlawful detainer. It's the landlord's side of the story. The complaint form is 4 pages. Let's go over it.
The name of each page of the document is at the bottom center. See the blue arrow.
The number of pages and what page you are on is at the bottom right.
This top part of the page is known as the caption.
The information of the person that filled out the form goes here. For the complaint, this would be the landlord or the landlord's attorney if they have one.
This block with the blue arrow is for the court's information.
The names of the parties go here.
To the right is the case number.
Does the person who is suing you have the right to sue you? Are they the owner? If not, are they a management company hired by the owner that has a right to file an eviction action? If not, are they your master tenant that rented to you? If not one of these 3, you can raise lack of standing as a defense. If they are not a person, if they are a corporation or a limited liability company that is in good standing with the Secretary of State. If not, you can raise that as a defense here.
Paragraph 6 tells the history of your tenancy. Is it accurate?
Paragraph 7 states whether the unit is protected by the state rent stabilization law called the Tenant Protection Act. One of the first things we do when we look at your case is called a jurisdictional analysis. What jurisdiction are you in? Is your unit protected by one of the rent stabilization laws? Rent stabilization is another term for rent control. Rent stabilization laws protect tenants from eviction and from large rent increases. Rent control laws are stronger and also protect the unit and future tenants from large rent increases. Rent control laws were eliminated in 1996 in California with the passage of a law called Costa-Hawkins. The rent control laws were replaced by rent stabilization laws. Under rent stabilization, if a unit is covered by the rent stabilization law, when a new tenant moves in, the rent is stabilized and rent increases are limited by the law. But if the tenant moves out or is forced out, the rent can be raised for the next tenant to whatever the market will bear. That means whatever the new tenant is willing to pay. This is a huge incentive for owners to get rid of long-term tenants so that they can raise the rent. In 2018, we tried to get rid of Costa-Hawkins and lost. We also tried in 2020 and 2024. When we try again, get active in the fight. In 2019, we passed a state rent stabilization law that offers protection against evictions and large rent increases. It is called the Tenant Protection Act, or TPA. The TPA protects all units in the state of California as long as they are at least 15 years old. It does not protect single-family homes unless the single-family home is owned by a corporation. It does not protect duplexes if the owner lives in the other duplex. It does not protect board and care facilities, subsidized housing, hospital facilities, and student housing. If your unit is protected by a stronger local law, the TPA does not apply because the stronger law is better. Paragraph 7 says whether the unit is protected by the TPA. Is it? You can verify on various websites. Paragraph 8 talks about the eviction itself. What kind of notice was served? There are 2 more pages to the complaint. We're going to stop the video here and you're going to read the complaint, including the notice that is attached at Exhibit 2. Do you understand what the case is about? We will wait for you right here.
Congratulations on getting through that section. Being sued is not fun. As a tenant in need, I had to face the reality that unless I wanted to pay thousands and thousands of dollars to a private attorney, I needed to buck up and learn all this stuff. Before, I was angry, frustrated, and desperate. Today, I am grateful for this opportunity. We are going to explain the prejudgment claim of right to possession, or PJC. If you need a break, take one and come back. It's time to paint the house.
If you took a break, welcome back. We are now going to explain the prejudgment claim of right to possession, or PJC.
The summons and complaint packet includes this paper. The title is at the bottom center, Prejudgment Claim of Right to Possession.
It is addressed to anyone who lives in the unit that is not
Named as a defendant. It explains to those people how they can defend the case. If you are not named in the complaint and you want to have a say in how the case is resolved, fill out and file the PJC and file it with an answer. If the case is a loser or you don't have a legal right to be there, you may want to stay out of the case. Are you okay with moving? You can choose not to defend the case and get ready to move when the case is resolved. If someone else is defending the case, it will take at least a month or 2, maybe more.
Now we're moving on to alternative dispute resolution.
The court wants landlords and tenants, i.e. the parties, to mediate. The backlog of cases is huge. The court thinks that mediation will help settle cases and lower the backlog. A mediation is a negotiation meeting that is facilitated by a third party that is neutral. A neutral is someone that helps the discussion but has no opinion about how the case should be resolved. Many tenants think that by starting this mediation process, they are protected and don't need to file an answer. False. File an answer first. Then think about whether you want to go to mediation. Before agreeing to mediation, watch video 2C. Do the 16 factors analysis. Come to the negotiation class. If possible, get a step 10 with your team. Decide on how you want the case to resolve. Then decide if you want to use this mediation process.
Now we're going to talk about the 5th amended standing order.
The 5th amended standing order includes the rules both parties must follow. In the courts outside of the Moss Courthouse, what we call the outlying courts, this document is called the Fourth Amended Standing Order. If you want to understand it, read it. At your first appearance, the judge may ask you to take two documents from a box at the counsel table, including the standing order. Say, "Thank you, Your Honor. I don't need them. They are already in my binder."
Now we're going to look at other forms.
The packet also includes a notice of case assignment. It tells you who your bench officer is at the moment. A bench officer could be a judge or a commissioner. We explain the difference in our TEP video 2H on what to expect on your first day of court. The case assignment page also tells you the court department number. This is where your initial court hearings will take place.
OSC, rate failure to file proof of service. O stands for order, S stands for show, C stands for cause or order to show cause. That's a term used for a lot of hearings. Basic, it says, you, party to this case, show up here in court and show cause. That just means explain to us why we shouldn't do a particular thing. You can ignore this form. It is directed at the owner and asks the owner to come to court if they have not yet filed a proof of service of the summons and complaint by the date indicated in the paper. There are other forms in the packet, and it is really not that essential that you know them.
How do you respond to the summons?
We went over this earlier. Option 1, call the Mayor's Fund for Los Angeles for help with your answer. The number is 213-584-1808. If you didn't do it earlier, pause the video right now. We will wait for you to continue. Seriously, go and come back. Call and get an appointment now.
Welcome back. If you live in a priority zip code, make sure you apply at Stay House LA.
If neither of those resources work for you, on day 6 after getting either the notice of unlawful detainer filing in the mail from the court or day 6 after getting the 20 to 60 page, sometimes 70, summons and complaint packet, go to the Shriver Project if your case is in the downtown court at 111 North Hill Street, or go to the Self-Help Center in any other court and have them help you file the answer. You may have to go a few times. Make sure that they preserve a jury. Ask them to preserve a jury.
If you can't get help at the Self-Help Center or the Shriver Project, which is room 115 of the Moss Courthouse, to prepare your answer on time, then use the Tenant Power Toolkit. This is an online resource, tenantpowertoolkit.org. If you choose the Tenant Power Toolkit, attend their training. Notice the blue arrow on the slide. Register for the training using this link. You can also just follow the steps online.
If you were unable to get an appointment with us through the Mayor's Fund, as soon as your answer is filed, come to our office and request to fly standby for an intake appointment.
Expect to be with us most of the day. Bring a headset with you and a charger so you can listen to the TEP videos on your phone while you wait.
Bring lunch.
Bring your patience and a positive attitude. Bring your entire case file with a current copy of your Registry of Actions. You can get the Registry of Actions or case register at the court.
You have 10 days to fix any errors in the answer. That is calendar days to fix errors on the answer. Please get into our office no later than day 9. And also, sometimes the Mayor's Fund sets an appointment, but it is after that 10-day deadline. Keep that appointment, but come earlier so that we can get that answer reviewed and, if necessary, amended before the 10-day deadline.
If the Mayor's Fund for Los Angeles did your answer, they will make an appointment for us to review it and for us to get you ready for trial. Remember, if your appointment is scheduled after your 10-day deadline to amend,
Walk into the office at 207 South Broadway, 6th floor, Los Angeles 90012, and fly standby no later than day 8 or 9.
Now we're going to discuss other motions.
We are here in the process.
There are rip-off services waiting to take your money to do motions rather than file an answer. $250 to $1,000 per motion. Usually these services charge $250 for the first motion, then $500 for the next, then $1,000. Before you know it, if you have paid more than you would have paid for an experienced private attorney to represent you in court. Do not fall for this. Often these services do these motions without a legal basis. Even when there is a legal basis, the judges are so used to these motions not being legitimate that they just deny them. Tenants are often confused after either winning or losing a motion and don't file an answer. If you don't file your answer before the 10 business day deadline,
the landlord will ask for a default judgment to be entered against you.
a judgment is entered against you, which means that you lose.
You get a sheriff's notice to vacate,
which looks like this.
6 to 10 days later, sometimes a little more, the sheriff will come and lock you out. We really recommend against filing these motions. They don't work and they will confuse you.
File your answer. Go to a self-help center.
Or the Shriver Project if your case is in the downtown court.
Or if they can't help you, use the Tenant Power Toolkit, tenantpowertoolkit.org.
And then, after that answer is filed, come to EDN no later than day 8 after you filed the answer and fly standby for intake so we can fix any errors and get you ready for trial. Remember to bring a lunch, a good attitude, your patience, your phone and headsets so you can listen to the videos while you wait, and also bring your entire case file, including the registry of actions.
We are now safely back on this side.
So, they asked for a default judgment, even though I answered on time.
We are here in the process. Notice the blue arrow.
This is the request to enter default. When people get this, they're like, why? I filed and answered. You're going to get this even if you've answered the summons and complaint on time.
Look at who the default is requested against.
Make sure it says all unnamed occupants at 1C. This means that they're trying to get a default against anyone living in the house that has not yet answered. And if they get that judgment, then anybody else not named in the complaint that hasn't answered will not be able to defend the case.
Do you remember this form? Adults that are not named in the complaint need to decide if they want to defend the case or rely on the named defendants to defend the case. Do you trust the named defendants? Do they have your best interests at heart? Will they take your opinion into account in making decisions? Is this case winnable? You might not want to get into a case that cannot be won. If you don't defend the case, you can wait out the process and move before the sheriff does the lockout.
Now we're going to move on to the trial request. You asked for a jury trial. They will ask for a non-jury trial. Your request for a jury trial will be honored as long as you file it on time.
The other lawyer uses this form to request a trial. And 10 or so days after you get this, you should get
the notice of trial.
Our side can request a trial. We recommend against it because you are usually not in a hurry to speed up the process. We need time to get you ready. You need time to get yourself ready. This is the notice of trial. Tenants often don't get this notice. This is why you need informed delivery at the U.S. Post Office. FedEx and UPS also have informed delivery. Make sure you sign up. If the court sends you something and you get an email with a picture of the envelope, but it doesn't arrive, investigate. Go to the courthouse and inquire about the mail you were expecting didn't arrive. Also, call the court once a week to see if a trial has been scheduled. Even better, go to the court and print a copy of your registry of actions to make sure a trial or other motion has not been set.
In most courts, the notice of unlawful detainer trial says non-jury trial, even if you properly demanded a jury. At your first court appearance, the judge will make sure that you filed the jury demand and fee waiver on time, or that you paid the $150 jury fee deposit on time. If you demand a jury and deal with the fee on time, you will get a jury. Verify now that you demanded a jury. Stop the video and take a look at your paperwork. Did you demand a jury? Did you pay the fee waiver or pay the fee?
To verify you made a demand, look at page 5, paragraph 5 of your answer to make sure the jury demand is there.
Or verify that you made a separate demand and that this separate document was actually filed. It needs a file stamp on the upper right corner.
The deadline for asking for jury trial is 10 calendar days from the date of mailing of this notice of trial.
The deadline for filing a fee waiver 002 form that specifically asks that the jury fees are waived, or the deadline for paying $150 jury fee deposit is 5 days before the trial date. But don't wait. If you have not done it, do it today and no later than tomorrow.
If you can't afford the filing fees and qualify, file the fee waiver forms.
The FW for fee waiver 001, FW 001 is the initial fee waiver application. The eligibility chart is right here towards the bottom. Do you qualify?
The FW fee waiver 003 is the order. You need an FW 003 signed by the judge that specifically says that the jury fee waiver was approved. If you don't have confirmation that you have requested the jury and filed the fee waiver FW 002, go to the court clerk and do it today.
Make sure the jury fee box is checked. Look at the blue arrow.
If you are serving subpoenas on inspectors or housing department staff, you also need an FW 002 fee waiver form that has this box checked and these words to explain.
Read all of the papers you get about your case. Text the first page to your team. Text only at 10 a.m. on working days. And if your fee waiver is denied, text all 3 pages and let them know that your fee waiver was denied.
If the court denies a fee waiver, sometimes you must appeal that decision. Often they just set a hearing at which you must prepare for and attend.
Training. I'm what? I'm being your goddamn slave is what I'm being, man. Now we made a deal here. So you're supposed to teach and I'm supposed to learn, remember? For 4 days I've been busting my ass. I haven't learned a goddamn thing.
You learned plenty.
I learned plenty. I learned how to sand your decks, maybe. I wax your car, paint your house, paint your fence. I learned plenty, right?
Not everything is as simple.
Oh, bullshit. I'm going home, man.
Daniel-san. Daniel-san.
What?
Come here. Show me sand the floor.
I can't move my arm, all right? What are you doing? What are you... Ow! Ow, what are you doing?
Now show me sand the floor.
How did you do that?
Shut up.
Sand the floor.
Please stand up. Show me sand floor. Sand floor. Sand floor. Big circle. Sand floor. Sand floor. Yes. Now show me wax on, wax off. Aye.
Wax on, wax off.
Wax on, wax off. Hey, wax on, hot. Wax off. Hot. Concentrate. Look at my eye. Lock a hand. Thumb inside. Wax on, hot. Wax off. Hot. Wax on, hot. Wax off. Hot. Wax on. Wax off. Ush. Show me pentafence. Up, down. Up, down. Up, down. Other side. Look eye. Always look eye. Show me penthouse. Side, side. Knucklist. Side, side. Side, side. Yes. Show me wax on, wax off. Cat! 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 Show me pentafence. Cat! Hey! Cat! Cat! Show me side to side. Cat! 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 Show me sand on floor. Cat! Hey! 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 Gosh. Stop! Oi. No karate training.
I'm what? I'm being your goddamn slave is what I'm being, man. Now we made a deal here. So you're supposed to teach and I'm supposed to learn, remember? For 4 days I've been busting my ass. I haven't learned a goddamn thing.
You learned plenty.
I learned plenty. I learned how to sand your decks, maybe. I wax your car, paint your house, paint your fence. I learned plenty, right?
No karate training.
May I introduce you to our very own Ms. Miyagi? Watch the videos, come to class. Watch the videos, come to class. Watch the videos and come to class. Watch the videos until you can teach the class. And then watch the videos again. And come to class because information changes all the time.
In the negotiation video, you will learn how to choose the right path. The path where you fight to stay, or the path where you negotiate time to move with forgiven rent, a seal record, and maybe some money to help you relocate.
You will learn to use the 16 factors to help determine your path.
You will learn how important it is to have a place to go before making a move-out agreement. So start looking for housing now so you will have options.
You will learn to save your rent. Either put it in a separate account or buy money orders, cashier's checks each month. If you are on government benefits, you cannot keep the funds in the bank. If you buy money orders, you need to make sure they don't expire and keep them in a very safe place. The money order must be filled out completely and stored in a different location from the stubs or the carbons. If you lose both, you lose your money. And if you have the back rent and want to pay and stay, bring the full rent in money orders or cashier's checks payable to the owner to each court appearance.
You will learn to keep a journal. For each entry, include the date and time and who you talk to. Include their name, include their agency name, the phone number, and other important details. The more detail we have, the better.
We will also teach you how to prepare the trial notebook. If you have not been able to get an intake appointment at our office, watch video 2F and come to the Thursday trial binder class. Be proactive.
We will teach you how to gather your evidence. Watch video 2E. Look at the list and gather these types of documents. Then look at the Proving Your Case handout and gather those documents. Put everything under these tabs in correct date order. and come to class.
We will teach you how to prepare for each court appearance. Join the role-playing Zoom class Tuesdays at 6 p.m. and also join us for the main TEP Zoom classes Mondays and Wednesdays at 6 p.m. Links and times for all of our classes are on our website, edn.la/webinars.
We will teach you how to keep calm and watch your tone.
We will teach you why fear can't have a role in your decision-making.
Why you must use your late night FM DJ voice, deep, soft, slow, and reassuring.
And never angry or whiny or an indignant tone.
We will teach you to listen to the question.
Answer the question.
Only the question.
We will teach you why you should be looking for housing even if you want to stay.
We will explain why you must have a plan for paying the rent. And if you're being bought out of a substantially below market rate unit and have been saving your rent, contact Erica Torres at Haven Services. This is a HUD-approved nonprofit agency that helps non-traditional homebuyers.
In the Tenant Empowerment Program, you will learn the law, the eviction process, the skills for achieving the best possible outcome in this eviction case, life skills, including the power of preparation, the benefits of patience, and the beauty of doing things right, and that you must learn to stand before you can fly. We are teaching you to be your own lawyer. This is boot camp, not summer camp.
People often ask, how often do I have to come to class? You don't have to come at all. You should come as often as you can. You will learn something new every time. You will absorb new information and develop a feeling of confidence. Don't be like our step student who was smart and educated and organized and busy and thought she could just cut corners. We didn't send her a lawyer to her trial because students that had applied themselves to the program took priority. She had not absorbed enough of that winning spirit or enough skills because she had not practiced them consistently. After a day of jury selection where we were guiding her by text, she took a move-out deal. We guided her through the negotiation via text, and she got a decent deal, but she did have to give up a below-market rate apartment. She could have won and saved her home instead. Minimally attend this TEP Pro class 2 times, each of the other classes 2 times, and the main TEP class at least once a week, and watch the videos over and over.
Our community is a ship in a storm. We are taking on water, and our lawyers are all in the water rescuing other tenants.
Help us bail water by educating yourselves. These empowerment classes on Zoom will give you the knowledge and skills you need to survive until a lawyer frees up or until you are strong enough to represent yourself.
We are available to you 6 days a week.
We can only give a lawyer to 10% of you. That means that 9 out of 10 of you need to learn to swim.
Help us be efficient in class by watching video 1A on how to get legal help.
And by reviewing from Zoom to Victory before every class.
Know how to properly rename yourself when you join a Zoom meeting and learn how to use Zoom. Watch a Zoom tutorial for your device. We want to help as many of you as we can, and we can only do that if you help us be more efficient. Come to class prepared. Have your personal information paragraph updated and ready to post privately in the chat when asked to do so.
If you had an intake appointment, the intake specialist prepared your personal information paragraph for you and sent it to you and to your team. If you did not have an in-person intake appointment, you filled out the intake application online and your team opened the case. You likely used this tool on the website to create the PIP. Don't send your PIP blindly. Don't put it on automatic send every morning. Use it to keep us informed of papers that you get. Read the papers, update the PIP, send the PIP with the first page of the papers to your team. And you do that at 10 a.m. Monday through Friday and not on weekends or holidays.
We are fighting for a better tomorrow.
A future where there will be enough lawyers for everyone.
A future where there are ample housing options that are affordable to all of us. A future with true rent control that prohibits rent increases on move out and no incentive for the owners to harass tenants into moving. Until then,
Communicate only on the PIP string, the group text with your entire team. Never communicate with just one person. A needed lawyer must evaluate everything a non-lawyer tells you. The attorneys monitor the PIP strings. If you email us a document, alert us on the PIP string because we don't monitor the emails.
if you are confused or need emotional or moral support, please join the Zoom Tenant Support Group.
You are here in the video series where the blue arrow is pointing.
Be a winner. Watch the videos and come to class.
Arrive on time. If you're more than 15 minutes late to an appointment, we will give your seat to someone flying standby. If you are late to court, you will lose automatically. Aim to get anywhere you need to be 45 minutes early.
Mute and properly rename yourself as soon as you join any Zoom class.
Watch our videos over and over and take notes. It takes multiple times to absorb the information.
Always have your current PIP updated and ready to text your team or ready to post privately in the Zoom chat when asked to do so.
Come prepared with your trial notebook and exhibit notebook. The trial notebook has all your court papers. Your exhibit notebook has your proof. Watch the videos on how to put them together.
Memorize your case number, your opponent's name, the opposing counsel's name, and your court department number. We will not waste time listening to you shuffle through papers to find this information.
Listen carefully when we are answering questions from other tenants. You never know when another student will ask what you were going to ask. And if they do, please don't ask the same question. Listen to the answer that we gave them. Also, you never know when another student will ask something you wish you had thought to ask.
Be respectful of all our attorneys, our staff, our volunteers, and the other tenants.
Practice that late night FM DJ voice. You will note that I don't do it effectively all the time. It's not my natural voice either. This more pressed voice is my natural voice. But you can rest assured that when I am in court, I use my late night FM DJ voice. That's why we have to practice it.
Practice your poker face.
And memorize the ship in the storm speech.
Because together we can all be winners.
We will see you in class.
We look forward to meeting you.
Please send us a 45-second statement of what the EDN Tenant Empowerment Program means to you and how we helped you. State that we can post it on our website and otherwise use it to recruit new students. If you want to be anonymous, show the back of your head or blur out the image. Wear at least a splash of orange. And remember,
When we fight,
we win.